I got a call last week from a building contractor in Chino, California. And the caller said, "John, I've got a competitor who's ripping me off on the internet. I need you to sue somebody." It turns out that the competitor was going to an online phone directory and substituting their own phone number for my caller's business listing. So when contacting my caller's business, instead of reaching my caller, instead they were contacting the competitor. In this video, I want to talk about this problem. Is it illegal? What can we do about it? Hi, my name is Carr Ferrell. I'm a patent attorney. Welcome back to my channel. Here's how the scam works. Apparently, there's an online listing service that lets you type in the name of a business that you're looking for. For example, backyard decks. And the listing service delivers to you a list of all of the contractors in your area that build backyard decks. For example, let's say my guy was Bob's Backyard Decks, located in Chino, California. So users would go to the listing site, they would type in backyard decks, and Bob's Backyard Decks would show up as one of the listings in Chino, California. Now, one of the first questions at the top of the web page that was asked is, "Are you Bob's Backyard Decks?" If this was your business, then you could go on to the listing site and add additional information about your services. For example, your phone number, your address, hours of operation, regions in which you worked, and the like. And according to Bob, someone was going into his listing and substituting their phone number for his. And he would find out about this and then go back onto the listing site, log in as himself, and then enter his correct phone number. But eventually, this competitor company would come in and substitute their own phone number for his, and so it went. Now, this seems to be a pretty low-budget operation, at least in this day and age when there should be some internet security associated with every web page. But for the sake of this video, let's just assume that Bob's description of the facts are accurate. Now, adding insult to injury, not only is the competitor taking Bob's customers, but the customers are calling Bob back later when there are problems with the deck and they need service on their deck, or they need to have warranty work performed on this deck that he didn't even install. Now, there's generally two types of solutions to problems of this kind. The first solution is self-help. That is, take steps on your own to try and resolve the problem. And the second form of resolution would be a legal solution. So let's talk about self-help first. In this case, I can think of three relatively straightforward methods of self-help. The first form of self-help would just be to call the competitor and tell them to knock it off. Often just facing up to the competitor is all you need to do. Letting them know that, hey, you know that they're changing your phone number, that they're stealing your customers. Knock it off. This isn't the way businesses should work with each other. Okay, that's the first form of self-help. If that doesn't work, then try calling the listing service. Ask for their help. Is there something they can do to help you out? Because this is harming the integrity of their listing service if people are calling one business and reaching another. It seems to me that a listing service would be more than happy in this case to help you fix the problem. Bob's Backyard Decks tried calling the listing service in this case, but apparently was unable to reach anybody. And a third suggestion I had for Bob was to consider hiring a programmer to go in and periodically check the phone number, make sure it was his phone number in the listing, and if it wasn't his phone number, to substitute his phone number for whoever else had inserted their own. Now, this is a little bit of a silly solution. It seems like it would be relatively straightforward to do. But on the other hand, the competitor could also hire a programmer, and then you have a battle between competing programmers, iteratively substituting the phone numbers of their clients into the listing. That really does seem a little silly to me. But if it does work, and the competitor doesn't hire their own programmer, then it may turn out to be a relatively simple solution. So if self-help doesn't work, you may want to consider legal remedies. Now, legal remedies are not always the most efficient. They're not always the cheapest. So try self-help first. But legal remedies can be very powerful, and in some cases bring a relatively quick resolution to an otherwise complex problem. In considering legal remedies, we first need to think about the legal wrongs that are occurring here. What violations need correcting? So in this case of Bob's Backyard Decks, there are at least two violations that are happening. The first is a trademark infringement, and the second is unfair competition. I want to talk about both of those. Trademark infringement is the unauthorized use of a trademark or service mark on or in connection with goods or services in a manner that's likely to cause confusion, deception, or mistake about the source of the goods and or the services. In the case of Bob's Backyard Decks, the competitor is inserting their own phone number into Bob's listing. And so the callers, the users of the listing service, are being confused as to who they're actually talking to and whose decks they are buying. The users of the listing service see the trade name of Bob's Backyard Decks, that is Bob's Backyard Decks, thinking they're talking to Bob's Backyard Decks, thinking they're buying from Bob's Backyard Decks, and in fact, they're calling and purchasing from a competitor. This is a misappropriation of the trade name of Bob's company, and therefore there's a trademark infringement that's happening here. And this trademark infringement is hurting Bob in two ways. First of all, Bob is losing business because customers thinking they're talking to Bob's business and purchasing from Bob's business are in fact going with a competitor. So Bob is losing that business. But secondly, to the extent that the competitor does a poor job, that bills decks in an inferior way and creates service problems, or in some other way diminishes or devalues the good name of Bob's Backyard Decks, then Bob's business is being hurt and his trade name and trademark are being devalued. So trademark lawsuits can be filed either in state court or in federal court. And for the most part, we tend to file trademark infringement lawsuits in federal court. The remedies for trademark infringement include a court injunction that the competitors stop the infringement of the trademark. Other remedies include monetary relief, return of lost profits, that is, profits that Bob's business otherwise would have earned had it not been for the infringement. And in some cases, the infringer may be required to pay the trademark owners attorney's fees. Now, the second cause of action that Bob's Backyard Decks has against the competitor is that of unfair competition. Now, unfair competition laws exist both at the federal level and at the state level. Broadly speaking, unfair competition is conduct by a market participant which seeks to gain an advantage over its rivals through misleading or dishonest conduct in trade or commerce. Now, in the state of California, and as in many states, the primary remedy is restitution. That is, you get your money back, you get made whole. However, in federal court, the remedies can be much stronger. For example, there's an unfair competition law called the Lanham Act, which may include up to treble damages and attorney's fees in some cases. So both of these causes of action, both trademark infringement and unfair competition, can be brought in either state court or federal court. So you should talk to your attorney about which is best for your situation and for your jurisdiction. Now, normally we'd start with a lawyer letter. Your attorney writes a letter to the competitor on their law firm's letterhead, explaining the ramifications of continuing this infringing activity. And normally, this is all that's required to bring this problem to an end. Very often, a strong lawyer letter will end the infringing activity. Nobody wants to be dragged into federal court, especially an infringing small business. So the lawyer letter may be a good first step. Now, it's really important to understand what happens next if that lawyer letter is ignored. And this is a discussion you should have with your attorney before sending the lawyer letter. What are we going to do if they ignore our letter? And the only remaining step at this point may be to file a lawsuit. Okay, that's all I really have to say today about trademark infringement and unfair competition. I just thought this was a pretty interesting call. Thank you so much for watching this video all the way through and for coming back to my channel. Please leave comments below if you have anything to add to this, or if you have other suggestions on maybe what Bob could have done or should have done. Anyway, thanks again for returning to my channel. Look forward to seeing you on the next video.